Are you worried that the government is going to use an expert witness against you in your criminal case? Do you think that you need to retain the services of an expert witness to defend yourself in your criminal case? We're going to try to answer some of these questions in this video here. Hi everyone, Attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. Today I'm going to talk about the concept of expert witnesses in the defense of a criminal case. Expert witnesses arise whenever either the government or the defense wants to demonstrate some sort of specialized knowledge to explain some of the evidence or information that's already presented in front of a jury or a judge if it's just a judge trial. The admissibility of expert testimony is governed by California Evidence Code 720, which says that expert testimony can be entertained once the witness who purports to be an expert demonstrates they have sufficient knowledge and qualifications to so testify. It doesn't require formal education or credentials. They just have to demonstrate to the court that they have the relevant qualifications in the relevant field of knowledge they plan to testify about. Also governing expert testimony is something called the Kelly-Frye Test. This states that in order to testify as an expert, the expert must be testifying about a type of scientific knowledge that is accepted within the relevant scientific community. The courts use the Kelly-Frye Test to act as what's called a gatekeeper to make sure that just patently unreliable scientific or expert testimony just doesn't reach the jury, for example. This has been contested in some situations. For example, ballistic identification or toolmark identification, whether it even comes under the purview as something that can be presented as expert testimony, or if it is, whether the methodology used is actually accepted within the relevant scientific community. If you want to look it up, there's some hotly disputed cases on that issue so far. But the gist of it is that in some cases, there's going to be some information presented in front of a jury that either party might feel requires scientific explanation. The government might, for example, present a DNA evidence expert, an expert, for example, like I said earlier, on ballistics or toolmark identification, on blood spatter analysis, or how battered spouses or victims of child sexual abuse typically present themselves. These are all things that we've dealt with at our firm and things that you and your lawyer should definitely prepare to talk about if you think they might be relevant in your case. But please remember, just because the government's allowed to call experts to present their case, it doesn't mean that you're not allowed to. In fact, the opposite is true. You're allowed in the defense of your case to present expert witnesses. If you feel you've been misidentified, you might want to present an expert on the subject of eyewitness misidentification to testify about whether things that compromise accurate witness identifications are present or not present in your given case. A jury might be motivated to, find you not guilty based on that. Or maybe a favorable report on that might motivate the prosecution to reduce or even drop the charges against you. Similar issues, handwriting identification in a fraud case, or really any case where handwriting is central to the government's theory of identification, or maybe expert testimony on medical forensics in a case where they're trying to allege that you strangled or injured the other party in a certain way. Well, maybe an outside third party might look at the medical records or photographic evidence provided and show that maybe the injury didn't happen as the prosecution is trying to allege. All of these things are worth talking about in the defense of your criminal case, especially if you feel that maybe the government might be trying to use some sort of scientific interpretation or theory against you. Please talk to your lawyer about this issue if you're concerned about the possibility of expert testimony being used against you in your case. Find out, one, if there's ways to attack or exclude the government's purported expert testimony, and also whether it's worthwhile to invest in your own type of expert testimony to see if it might be useful. Other examples might be in a DUI case where you might want to have a toxicology expert to testify about how your body may have actually processed alcohol consumed and whether the BAC readings are actually accurate, or whether the breath or blood sample was properly taken. I can go on and on about these examples. The point is they're worth discussing with your attorney, no matter what type of charge you might be facing. Thanks, and stay safe out there.